Today I happened to file an anticipatory bail for one of my client. So I thought why not I make a video on what is anticipatory bail, where to file an anticipatory bail and the step-by-step procedure that is involved in filing an anticipatory bail. So first, what is an anticipatory bail? An anticipatory bail is a pre-arrest bail. Basically, it is a direction to release the person on bail even before that person is arrested. Now, who is eligible for anticipatory bail? Who can file an anticipatory bail? Any person who apprehends arrest or any person who is under the belief that there is a cognizable offense, a non-bailable offense filed against him, can file an anticipatory bail. Now, where do you file an anticipatory bail? Anticipatory bail is to be filed before the Honorable Sessions Court under Section 438 of CRPC. Now, if at all your bail application is dismissed by the Honorable Sessions Court, then you approach the Honorable High Court under Section 438 of CRPC with an anticipatory bail application. Now, what is the step-by-step procedure that is involved in filing an anticipatory bail? Now, first comes the anticipatory bail application. Now, the anticipatory bail application is divided into three parts. First is the cause title, thereafter comes the body of the application, and thereafter is the prayer. Now, in the cause title, you need to mention before which court you are filing that particular application. Secondly, the details of the applicant, that is his name, place, age, his occupation, his nationality. Thereafter, you mention the details of the police station at which the concerned offense has been filed. Thereafter, you mention the section under which you're filing that particular application. That is, in our case, since it is anticipatory bail, you need to mention under Section 438. Now, let us come to the body of the application. Now, the body of the application will include the sections, the crime number. If at all you are not aware about the crime number and section, then you can leave it blank and you can mention that crime number and sections not known. Now, in the body of the application, you can even set up your case. You can set up your defense. Thereafter comes the prayer. Now, one thing you need to remember while filing an anticipatory bail application, that you need not file a separate application seeking interim anticipatory bail. Now, the prayer seeking for interim bail can be mentioned in the main anticipatory bail application itself. So there is no need to file a separate application for interim anticipatory bail. Now, this anticipatory bail application needs to be supported by an affidavit. Now, some courts insist on filing an affidavit along with the application. Some courts do not insist. So depending on the court, either you support the application with an affidavit or not. Thereafter comes the wakalatnama. Now, wakalatnama signed by the applicant gives the concerned advocate the authority to appear on behalf of that applicant to plead. Thereafter, if at all there are any documents involved, or if at all the applicant wishes to rely on any documents, those documents can be annexed along with the application. Thereafter, you affix the prescribed court fee on the application, prescribed court fee on the wakalatnama. Now, on the application, it will be somewhere around 10 to 20 rupees court fee. On the wakalatnama, it will be somewhere around 20 to 50 rupees court fee. So basically, the entire cost of the court fee for an anticipatory bail application will be somewhere between 30 to 70 rupees. Now, if at all the process fee is required, you can even annex the process fee if at all it is required, only then. Thereafter, once your anticipatory bail application is ready, you go to the registry of the concerned court. You file the anticipatory bail petition before the registry. At the registry, the bail petition will be registered. Once the bail petition is registered, it will be marked to the concerned judge. Once it is marked to the concerned judge, you need to follow up with the registry to which judge that particular anticipatory bail application has been marked to. Thereafter, on the given date, you appear before that honorable court before which the anticipatory bail has been made over to. Thereafter, you mention your bail application before that honorable court. The honorable court will issue notices to the respondent, that is the concerned police station. You need to take those notices, serve the police station with those notices. Now the notices will have the date on which the hearing or on which the concerned police station needs to file their say. Now on that particular day, the concerned police station will give their reply opposing your bail application. I have not come across any reply or say of the investigating officers wherein they have not objected for an anticipatory bail. So their usual objections will be that the offence is serious in nature, the investigation is at preliminary stage, the custody of the accused is required for the purpose of recovery and whatever purpose. Now all these things will be mentioned. Thereafter, the arguments will happen between the public prosecutor and the advocate that is appearing on the applicant, and thereafter the honorable court will fix the anticipatory bail application for orders. Now, at the time of orders, either the anticipatory bail application will be allowed. If it is allowed, well and good. If it is dismissed, then you approach the Honorable High Court with your anticipatory bail application under section 438. If at all it is dismissed by the High Court also, then you approach the Honorable Supreme Court under special leave petition. If at all it is dismissed by the Honorable Supreme Court, then you have no other option than surrendering yourself and filing a regular bail application that will be either under section 437 of CRPC or under section 439 of CRPC.